Good afternoon, friends. Very important decision by the Honorable Apex Court on availment of transitional credit under GST. One of the earliest litigations under GST on transitional matters has almost been settled by the Honorable Apex Court by its decision in the case of Filco Trade Center Private Limited and others versus Union of India. If we remember, almost 4.5 years back, the Honorable Gujarat High Court was among the first high courts to decide in the case of Siddharth Enterprises that the transitional credit under GST, that is the credit of those taxpayers which were registered under VAT, Central Excise, Service Tax, etc., to flow as a transitional credit under GST is a right of the taxpayer. It is a property of the taxpayer under Article 300 capital A of the Constitution of India and cannot be denied to the taxpayers without the authority of law. So, due to technical glitches in the GST portal and due to procedural errors, it was held that transitional credit cannot be denied to the taxpayers. Thereafter, a flurry of matters have been decided by the high courts of all the states almost, and most of these matters have been held in the favor of the taxpayers. The issues were varied. In one of the cases, a taxpayer has made a clerical error in filing the TRAN 1 by which he did not mention one of the digits in the amount for credit. That is, say instead of 10 lakh, he forgot to mention 10 and it became 1 lakh. The question was whether for this his property in the transitional credit could be deprived to him or not. Various other issues were there, and thereafter the department, the board came out with notifications, circulars, orders by which it was agreed by the board to provide the transitional credit only in case there was a technical glitch. We all remember that 27th of December 2017 was the last date by which the transitional 1 form or TRAN 2 form, TRAN 1 for the purpose of TRAN 2 could be filed and even revised. However, then there was an issue as to what is this technical glitch and how do you prove it by the means of an audit trail. For example, if you cannot get into the GST portal itself, how would you get an audit trail? Because audit trail was only available in case you could get into the GST portal. Again, a volley of High Court orders were pronounced in matters. In a very recent judgment by the Honorable Calcutta High Court in the case of Udgit Nirman, the Honorable Calcutta High Court has remanded it back to the department with an instruction to follow the earlier High Court orders. So many issues were there in availment of transitional credit, and so many High Court orders were there, more than 400, on which the Honorable Apex Court has delivered its judgment today. We will discuss as to the judgment and how it could benefit the aggrieved taxpayers for the purpose of availing transitional credit. The Honorable Apex Court in the instant case of Filco Trade Center Private Limited has held and directed the GST network to open the GST portal from 1st of September 2022 and keep it open till 31st of October 2022 for taxpayers and aggrieved assessees for the purpose of filing their transitional credit claims in TRAN 1 or TRAN 2 or TRAN 3 forms. So even in case you have not filed your TRAN 1, could not file, and you are an aggrieved person, then you can take this opportunity of filing TRAN 1. If you could not file TRAN 2 because you could not file TRAN 1, you can take the opportunity of filing TRAN 1 and TRAN 2 both. If you filed your TRAN 1 but could not file your TRAN 2, you can take this opportunity of filing TRAN 2 if you are an aggrieved person. Do you require to be a petitioner who has filed a writ petition in the High Court to avail of this opportunity? The Honorable Apex Court has held that you need not be a writ petitioner in any High Court, but even if you are an aggrieved person who has been deprived of his transitional credit, you can still take this opportunity from 1st of September 2022 to 31st of October 2022 to claim your transitional credit in from TRAN 1, TRAN 2, TRAN 3. After you file your claims, the department would have got 90 days from the filing of your claim to verify this transitional credit. In case they accept the claim, then it flows to your input tax credit ledger. If they reject the claim or deny the claim, then of course, as per the principles of natural justice, they would have to give a hearing to you as a taxpayer, and in case it is disputed, then your right to contest it can be exercised. The CBIC has been directed to issue guidelines in this behalf, and over the next few days or weeks we can expect guidelines in the matter. And very important to know that in case during this period there is any technical glitch again in claiming the transitional credit, then the order may not be considered to have been fully complied with. Therefore, this is an important and a welcome opportunity. Various senior counsels across the country have argued this matter and put in a lot of effort for fighting for the right of the taxpayers. Taxpayers can take this benefit of this order over the next few weeks and months and ensure that their rights are not denied. Thank you very much. Stay tuned for further updation analysis on GST, income tax, DGFT, customs matters. Please do like, share this video and channel for maximum publication. Thank you very much.